Welcome back to the big question. We're looking at the legal and political implications of the termination of Ruto and Sang's case at the ICC by the trial chamber today. In studio tonight, Nabil Orena, who was already with us earlier. Thank you so much for making time for the big question. We also have Javas Bigambo, political analyst. Thank you so much. And Dr. Korisi Ngoi, Ruto's legal advisor. Thank you, gentlemen, for making time for the big question. As you give us the initial reactions to the decision by the trial chamber, I want to look at that decision by the majority, that is Robert Fremer and Judge Chide Ebuosuji. The charges against the accused are vacated, and the accused discharged without prejudice to their prosecution afresh in future. Now, I'll start with you. It means the case can be brought back in future?
That's the possibility that the chamber has opened, that the prosecutor can bring fresh charges against the accused persons on the basis of the situation that they were charged previously about. But looking at what has happened and how this case has gone on, I do not see that possibility. But that is a possibility that has been open for the prosecutor.
Right. Dr. Singoi, you being the legal advisor of Deputy President William Ruto, first, how do you take that? Did you see that coming?
Absolutely. I think this case began to collapse long ago. When the prosecutor appeared to be engaged in a fishing expedition, basically to try to compel witnesses to appear, to try to use recanted evidence, among others. And so for us, we've been very, very confident that based on the standards and the threshold, you know, on the Rome Statutes, there was just no way that a tribunal properly exercising its mind on the charges would have found that there would be a case to answer. And so we expected, in fact, that there would be, you know, an acquittal, that there would be a total vacation of the charges, you know, against the Deputy President and Mr. Sang, and therefore I think this is really a great day that has happened.
But in terms of, I mean, the case, there's a possibility that it could be brought back. I mean, how do you take that? Did you expect that, and how do you take that?
I think it represents really what has systemically been wrong with this court. Because for a court to hear over 30 witnesses who basically have provided no evidence that links the accused persons with the charges and does not incriminate them, you know, for a court then to say, look, that, you know, that we will not make a determination and that we will declare a mistrial. I mean, that just says how insidious and how dishonest the court actually is, that it lacks, that the judges lacked the moral courage to actually be able to say, look, there is no case here, you know, we will dismiss it as it is without more.
And the legal representative of victims is already disappointed. He's talked about this, and the ICC outreach team, they were addressing the media in Nairobi today, and they're actually asking the prosecution to appeal.
Well, ultimately the Iron Curtain has fallen with the heavy charges against the Deputy President and former journalist Arap Sang, and with it, you know, the darkness of those terrible charges have now been swept away, of course, with the possibility of the charges being brought back on the strength of the prosecutor's efforts, if at all there will be any other steps taken by the prosecutor. But of course, with this decision, which the wisdom of the judges has now rendered, it is evident that the judges are at conflict with the prosecutor's weight of evidence that they had adduced initially, of course, with MorenoOcampo and now with Fatou Bensouda before the court. And this also speaks to various issues. One, the issue of justice, and the question would be justice for who? Because here, of course, we see that the learned counsel for the victims is already up in arms and requesting the prosecutor to appeal this decision. And here, of course, it's with the primary interest of justice for the victims. Because in the end, of course, we must all appreciate that while justice has been served in this matter, in the interest of the victims, it is nearly evident that they're the ones who feel that they have been left in the cold. Because while of course we can see that from part C of the decision of the judges, they are welcomed to present their their concerns before the honorable court. But you see, it must not be seen as well that the issue of the interest and justice for the victims is merely a footnote in this whole affair.
But that's the problem. That's the problem, Hussein. We're really saying that this entire enterprise has been a massive letdown for the victims, because 6 years down, this trial, the court goes ahead to declare a mistrial. What does that actually say to the victims? And this absolutely unreasonable hope that they're now setting out for the victims, is totally without foundation. And so we are saying that the entire framework of the ICC fails to accord any substantive justice to the victims, and we need to totally rethink, whether in fact it's worth it to continue. Right,
and I think the President has alluded to that, and so has the Attorney General, Professor Gidemuga. We'll come to that shortly. But being in Deputy President Ruto's legal team, have you heard anything from the prosecution? Or are they planning anything after this decision was made?
It's their right. Clearly, they can only appeal, as you know, only on legal issues, on questions of law, which means that they must review the decision and ask themselves whether, in any of the propositions the judges have made, there's an error of law that is appealable. And so therefore, it's not going to be on questions of fact. It's not going to touch anything regarding the fact that the judges have actually determined that there is no network, that all the allegations around meetings were being planned, that there was an organization policy to annihilate communities. None of those issues are going to arise. So the question would just be, is there a legal error that will be appealable upon?
Do you think it's possible they do that?
Well, my opinion would be that, of course, they have that right to appeal if they wish, but they can only appeal, as my colleague has said, on the legality of the assessment, the standard, especially the criteria that was used. But it's a straightforward criteria that if you assess this kind of evidence and there is no possibility that with this kind of evidence you can sustain a conviction, then you must terminate the case. So if they choose to really appeal, they must be so sure that the chamber went wrong on the criteria they applied, and in regard to the evidence that had been presented. And I think really for them to appeal, they must be sure that they have a possibility of going ahead with this case.
Right. The majority judges, that is Buyo Suji and Fremer, apart from saying, the evidence, there was no evidence here, enough evidence or sufficient evidence. One thing Judge Buyo Suji said is he declared a mistrial because, in his view, weakness in prosecution case may be explained by demonstrated incidents of tainting the trial process by witness interference. What do you make of that?
Well, of course, there has been a whole wave of accusations and counter-accusations about matters to do with the witness, interference, whether from the part of the prosecutor, etc. The prosecutor herself has raised her hands in the air, indicating that she fears various witnesses have been interfered with, and this whole matter has been a fiasco. And that also raised the trepidation around this entire matter. And of course, it punctured holes into this whole matter, and that's why we saw her seeking to see whether she can use recanted evidence in the end, and we know that the appeals chamber decided otherwise against that kind of decision. And this whole matter now has thrown eggs on the face of the prosecutor. In the end, it is an indictment on the part of the prosecutor, because they did, in an interesting way, not so diligent a job. And it commenced when the former prosecutor, MorenoOcampo, said that he wants to use the Kenyan situation as an example. That itself took a political, inclination, which did not seem to most people that it was purely in the interest of justice.
So when Kenyatta, like today, says, you know, he is accusing the ICC of giving Kenyans false hope, you agree with that?
Well, I think it is agreeable that too many people are feeling that justice was not entirely served, because the entire, you know, the prosecutor and that entire office did not do a diligent job in terms of gathering the evidence, etc. They're using, you know, various means to gather the evidence, and which in the end has let down the cause of justice. In the end, I would say that this decision rendered today does not necessarily call for celebration of our nation. It calls for reflection. We need to go back to the drawing board and reflect deeply as a nation how we want to move from this point moving forward. We need to see how we renegotiate not only our past, but the course of justice with regard to the post-election violence.
Right, there was also a dissenting opinion, Justice MorenoOcampo, and I want you to talk about this, Nabil, saying, you know, the 3 charges of murder, deportation, and forcible transfer and prosecution could be sustained, albeit in a limited geographical locations. What exactly does that mean?
Well, a dissenting opinion is merely that, an opinion. The majority carried the day. You know,
the substance of what she's saying is what I'm asking.
Yes,
what does that mean?
The judge, in her view, in assessing and applying the criteria that they all had to apply, she thought that in her view, and this is why the trial chamber, which has the benefit of looking at the facts, is better placed at giving its own determination. In her view, in her own evaluation, she feels that certain crimes or certain elements could have been satisfied, and there was a possibility that this could be sustained, indeed, so that the accused persons could be put on their defense. But she finds herself in a minority, and you know, the way they arrive at rulings and judgments is through deliberation and, you know, considering all factors, all facts. So, well, she is entitled to her opinion, but in this case it did not prevail.
Yeah, but if I could just quickly comment, I think it's really unfortunate that the Judge Kabusha thought that that there was even a modicum of possibility to sustain certain aspects of the charges, and she goes ahead to suggest that probably what the court could have done was to recharacterize the charges by way of Regulation 55. You know, again, a very problematic proposition, Hussein, because we have always said that the problem with legal recharacterization is that as a defendant, as a criminal defendant, you are confronted with certain charges at the very beginning. Now, you begin to defend yourself on the premise that you are charged with ABC. But midway the trial, as Kabusha is proposing, the court basically alters the parameters of the charges so as to make it more, to increase the chances of your conviction. Now, that is problematic from a fair trial, you know, perspective, and that's why we're saying really that her dissent, even though she's in the minority, like my brother says, you know, is completely regrettable and of no basis.
All right, Javas, being a political analyst, I mean, there's always some political implications to this decision. First, how much of a baggage was it to the Deputy President, and what does this mean for him now?
For about 6 years, the Deputy President has been having a millstone around his neck. And today, that load has been dropped off his shoulders. And this means that he politically will be lighter. He will now want to discharge his duties, of course, as Deputy President. But more than that, he'll want now to, you know, sprint into the political field, knowing full well that all that was bugging him is now behind him. He is now actually, in a manner of speaking, far much more prepared to face a more glamorous future politically for him, now that he's trained his eyes on the 2022 run for the presidency. And far more than that, you see, given that he's been looked in that framework of being a suspect at the International Criminal Court, that having now been put aside, it gives him a chance now to be that political juggernaut that possibly he could have been prepared himself to be.
Do you expect a different kind of Ruto going forward?
Well,
and where?
Well, we expect now possibly a more shrewd politician, now that he has got all the energy, and with now this at the back, at his back, we expect to see a more vibrant, deputy president, and seeing him possibly far more charged in preparation for the kind of succession battle that's shaping up after the possible re-election of the President Uhuru Kenyatta. So, of course, we're likely to see a more energetic deputy president who is stepping up now to the stage with possible more style.
I don't know if my Dr. you want
just a quick comment on that. I think obviously, you know, the deputy president has never been impaired in terms of undertaking and discharging his constitutional and legal responsibility as Deputy President of the Republic of Kenya. I think he's an agile, able, you know, and highly invested, you know, political actor, and this basically gives him an opportunity then to do even more in terms of serving the country. And I think the gist of the president's statement basically is that, you know, as a duo, they are now trained and focused on really reconciling and uniting the country, which is, I think, a very critical agenda emerging out of this.
Okay.
My view would be that it's quite unfortunate that the ICC did not definitively, you know, say that there is an acquittal, because they've put a lot of energy, you know, into the defense. You've taken people through a long process in the court. But now I think it's a good opportunity for the deputy president to put this behind him, because legal work, and when you're facing legal troubles, it takes a lot of time, you know, to sit down with the lawyers, plan, and also, you know, it eats up you. So as a politician, I would think I would agree with Javas that he's more re-energized to put more effort on his work, and also the next election.
You talked about how long the process was, very briefly now, because let me get some text here. Mutai Geoffrey from Bomet asking, who will meet the cost used by Mr. Ruto? Maybe you should respond to that.
Good question. Really. You know, again, I wish, you know, we could tax our bill at this point, the manner in which we do in domestic codes. But unfortunately, you know, this is one of the cases where the deputy president was not a recipient of legal aid from the court. You know, as you know, Sang's entire defense has been paid for directly by the court. You know, and so unfortunately, it's a cost that we must bear. And so, if you think in repression, clearly, I think the deputy president has borne quite some heavy responsibility in that regard already.
Okay, another question here is run up. Please ask the panel. This is Sam from Thika. What happens to the witnesses who lied to the court? Are they being prosecuted? Should they be prosecuted?
Well, I think Bensouda has a big task, especially in regard to the allegations of witness interference and witnesses who deliberately lie to the court. And even the majority has alluded to it, that most of these witnesses, even the prosecution witnesses, were deceitful witnesses, witnesses who lied to the court. So I think to sanitize the whole process, and as part of what next, it should be to look into these allegations, especially the people who misled the court, people who allegedly influenced others, so that at least it's a clean process, because there's so many lessons to be learned from this process.
Right. Another text here actually from David Kosing, a member of parliament from Pokot, says, today we witnessed the success of truth, the truth that the Deputy President Ruto and Sang were all the way innocent. As the sponsor of the petition, I think he's talking about the ASP, I thank all honorable members who supported it. The success today has given the country an opportunity to move forward and focus on the victims. I'll wind up with that and ask you, because the President has talked about it, the Attorney General has talked about it, now to look for local mechanisms so that the victims can finally get justice. Do you see that working?
It would be possible. Of course, with the Kenyan situation of the ICC, the universalistic nature of justice has not been served. And it is incumbent upon the government of Kenya to see how to put in place a mechanism that would ultimately serve justice to all those, especially the victims. But far more than that, we appreciate that Kenya has dealt a blow to the International Criminal Court. Africa itself has risen up to position itself as a very compelling voice on the issues of the globe. And these are questions that we may want to confront ourselves in terms of the realm of justice globally and even continentally. But Kenya now has got a more critical task to play to make sure that the interests of justice are served. Our judicial system should make sure that they do not lose sight of the interests of the victims of the post-election violence.
Right. Thank you very much, gentlemen. Dr. Korir Simoei, Ruto's legal advisor, Nabil Orina, who is an advocate and international criminal law expert, and Javas Tigambo, the political analyst. Thank you so much for taking time for The Big Question. Keep talking to us on #2 for #2 and on Twitter using the hashtag The Big Question. We'll be back after this break.